panel session, and we have a topic of IP and technology transfer, discussing the role of intellectual property in technology transfer, licensing agreement, and collaboration between academia, research institutions, and industries. For that, I would like to welcome on stage the moderator of panel discussion, Ramesh Kumar Verma, who is an AGM IPR, Tata Chemical Limited Innovation Center, Vaibhav Khanna, Head of Intellectual Property, Sterlite Technologies Limited. We have Dr. Bijay Kumar Sahu, Senior Regional Manager and Head, IPFC and TISC, Associate, Editor-Invention Intelligence National Research Development Corporation. And also we have Dr. Amaresh Panda, Head Technology Transfer Officer, KIIT-TBI and KIIT University. Thank you.
Good afternoon, everyone. Welcome to the IP and technology transfer panel, and where we are going to discuss the role of intellectual property in technology transfer, licensing agreement, and collaboration between academia, research institutions, and industries. So, along with me, I have my panel members, Dr. Bijay Kumar Sahu, who has joined virtually, and with me, Dr. Amaresh Panda joined. So, to begin with, I introduce myself. So, my name is Ramesh Verma. So, I have around 20 years of experience, and I started my career with the research in one of the CSR research institute. After that, I moved to the service industries where I worked on a consultancy on IP and technology, and then moved to Tata Chemicals 15 years back. And in Tata Chemicals, I have played several roles, including IP management, collaboration, innovation, and also some regulatory aspects. So I'll request my Dr. Amaresh Panda to introduce himself.
Yeah, already you know the same audience, so no need to repeat about my introduction. As all knows, because I am from pharma background, and more than 17 years I am taking care of that intellectual property and portfolio management with technology transfer. Earlier I was sitting in big pharma company. I am hiring technology from academia, and right now I am heading a RTTO, Regional Techno Transfer Office, where I can say selling technology from academia and startup company to bigger organization. So I have seen both the face of a coin. Okay, so this much it's enough. Yeah.
Thank you, Dr. Panda. So I request Dr. Sahu, if you can listen us.
Yes, I am audible. So I think everyone knows already I introduced myself, so better to skip this to manage the time.
Okay. So to begin with this session, so when I saw the topic, to my mind, two songs came to my mind. One thing, Ekla Chalo Re, so it's a very popular Bengali song, which I think written by Mr. Rabindranath Tagore, which says that if nobody listens to you, go alone. And second song came to me that Ek Akela Thak Jayega Sathi Haath Badhana. So it's a Mr. Sahir Ludhianvi. So when we talk about collaboration and licensing in terms of technology transfer, IP licensing, so these two songs plays very well in the role in this thing, because there are two parties, one going alone, other party also going alone, but there is a need that both has to come together and go together, because one cannot achieve what they want to achieve. So in that, I think collaboration and technology transfer is one of the essential component of the overall, when we talk about innovation, research and development, commercialization, and going forward, we are saying developing our developed country want to be developed country. So this has to play a big role. There's no doubt about that. And in India, we have a lot of universities, a lot of research institutes which are innovating. which are doing cutting edge science discoveries, a lot of research institutes who are developing a lot of new innovative technologies. And we have Indian companies who are keen to not only launch new products and technologies in India, they also go globally. And they do try to work with the academia, they try to work with the research institutes, but still there is a lot of opportunities are there, a lot of gaps are there, a lot of challenges are there, and same time, a lot of good stories are there. So begin with that. So I have my panel members, and I'll request to share their experiences, what goes well, where things can be improved on. Yeah. So first, for any, so I'll start with Dr. Panda. So if he can share his experience, how it works.
Yeah, thank you. You know, collaboration between two parties, you know, techno transfer, IP commercialization, nothing but you have transfer some technology from lab to the market, you know. As for my experience, as I mentioned, I played from both the sides. The inventor all the time play a role of mother of each and every invention. But when it's come to the buyer, to the industry side, they will act like a mother-in-law. You know, saas jaise hota hai, you know, mother-in-law play they are playing. So we as a technology transfer professional, we have to balancing the situation as a moderator between a mother and mother-in-law. Before to start in detail about the technology transfer process and everything, I would like to share a few things. The world best product, starting from Google search engine to pacemaker, seat belt, your Taxol cancer medicine, then your penicillin antibiotics, everything has been, the invention has made from the university, not from any big company. Still COVID-19 vaccine as well. You know, this is the strength of the academia ecosystem in the world, mostly in Western countries. Because there is a Bayh-Dole Act 1980s in the US. Based on that act, that the process of IP commercialization from academia to the industry is evolved. So what I mentioned in all the technology has been matured till at least I can say field validation or proof of concept in lab. After that, all the big company, they're running to the universities to hire the technology because they have mastered in the market forecasting, and once they know there is a good technology, they come to you, they hire the technology. You know? In my career, 15 or 16 years in pharma R&D, you can touch out of 10, 6 to 7 pharma product, you know, inventive product have been invented from the lab of a university, not from the pharma company. Because in US or Europe, they have a very good, I can say, solid structure. They are funding from the presidency fund in US for that basic research should be going on in university level, and they are getting huge money from them. And based on the Bayh-Dole Act, the universities can generate revenue from that invention to their university. So the two things will impact a lot in US ecosystem to bring this culture of IP commercialization. For IP commercialization, three things measure a lot. One is your technology valuation, second one is IP valuation, third one is market valuation. As for the technology valuation, this is technology readiness level. There is a scale from 0 to 9. You know, once you have done that proof of concept in your lab scale, then field validation, pilot scale validation, pivotal scale validation, then you can launch your product to the market. But as per the financial budget available to that academia or to that startup company, they can easily reach to the stage of POC, proof of concept in the lab scale.
But after that, how to do the field validation, how to do the pilot validation, it's very difficult to a startup company or to a academia, because the fund what they are getting maybe from government or maybe from some ventures capitals is not sufficient to reach to conduct all such type of validation. In technology transfer or IP commercialization pathways, this is called death valley. You can easily reach to the proof of concept. This is called scale 3. But to reach the pilot validation, it's very difficult. They are facing a lot of, challenges. So that's the technology transfer office, the IP commercialization play a bigger role. If there is a complete IP valuation, if there is a very positive growth on that, if you are doing your IP greening with a good TRL at least 4 or 5, and there is a market forecasting, then it is easy to transfer or to sell your technology or to commercialization of your IP to a bigger company. In India, basically, as you know, after US, India is in the second highest number in startup company registration, startup company as per the data, global data. And more than 100 startup companies unicorn right now, more than 100 companies. That's a very good environment in India and very good support from our union government, also most of the state government as well. But the main difficulty, what I found in my career acting as a technology transfer professional, all the academia or startup companies, basically, let's say I'm giving you an example in case of they are developing some biologics or some pharma product, they are not acquainted what type of product they should generate. Let's say, as I mentioned, there is a called ICH guideline, stability data, because in pharma sector, stability, safety and efficacy, 3 things play a major role. But most of the startup company or academia, they are not that much knowledgeable about that ICH guideline, what type of data they should generate. Though government have good facilities, good regulation, good funding, process to enrich them, to strengthen their ecosystem, still we have to do a lot about the technical aspect. We don't know what are the data we should generate, what are the data we should have in our logbook. Then it will easier to transfer our technology from the smaller company or from the academia to the industry. But in Western country, this is very much they have, they have the system, they have robust system, they know what type of data they should generate. And initially they are collaborating with the industry. They are putting some mentors into the ecosystem, what are the data we should produce to impress to a bigger company, to sell our technology or to commercialize our IP. So this is the basic, difference between our ecosystem to the Western culture. And in India, when I am just changing my role from industry to this, techno transfer professional, few of my seniors, they, laughing at me, Amaresh, what are you doing? Do you think you can transfer a pharma product from academia in India to a MNC? It's completely it's quite impossible, because the standard is like that. Still, I accept the challenge, and till today, I have transferred 3 pharma products, to the pharma company, because I'm putting all the, effort, what are the data should be generated, and after that, the pharma company will look at to the system. So these are the, few part in the brief I am sharing, so what are the difficulty we are facing, but the strength is there. A startup company, a academia, or a company also. Let's say bigger pharma company like Sun Pharma, Glenmark, and if you can search, in India you are not getting any bigger pharma company. They have a product themselves. That's called innovator company. Let's say Pfizer, Novartis. You are not getting in Indian pharma company. They have also generated good, molecule, but once they reach phase 2, they are selling their technology to bigger company, because they don't want to face the challenges throughout the globe. So because we don't have that much of courage, we and the Indian people, normally Western people call us, our country is a service-based country, not a knowledge-based country. We are not generated revenue from our knowledge. We are generating our revenue from services. So we have to change the tag. Best, what will help us? This IP commercialization. As of now, India in global IP index in 42 and innovation index, it's in 40 states. Out of 55 countries who are contributing good in World Economic Forum, India still in 42. You can think. But in GDP, we are in 5. In GDP revenue and everything, we are the richest 5 country. But in IP, we are sitting at 42 out of 55. Then we all have to do a lot to change this tag, because we should have, because above to us, Singapore, very small country. Even Malta is a very small country. In IP index, that country is higher to us. Can you imagine? We have this much of brain we have in India, still we are sitting in number 42. So there are so many limitations and everything. We have to do a lot to change the ecosystem.
You touched upon a very interesting topic, that licensing of a IP and licensing of a technology, because when you say, it means there is a difference. So a lot of time when people wants to license or collaborate with somebody, they talk about they have a technology. Actually they have a technology or not, sometimes it's very confusing thing. Sometimes they have only IP, sometimes they have only technology and IP something different. So I would request Dr. Bijay to talk about his experience, what he is like to share on this topic, that licensing of the IP and technology, and what he sees as a challenge that what people initially face with when they go about it.
Thank you, Mr. Verma. And when we talked about intellectual property and technology transfer issue, we must not forget the technology and also process as management of intellectual property. So one aspect in the Indian context, I will again repeat, one size of shoe cannot fit all. Indian has its own problem and we have many challenges. And in that challenges we are mitigating also, and that's the beauty of India. So, so far as the policy practice, we have enhanced and compliance all the norm. We have a IP policies, and that has been derived from universities. UGC advise all the academic institution, university to have a IPR policy, because that is the safeguard they can create at institutional innovation at a university level. Second is Government of India has also enhanced the technology transfer organization in every, I mean, as Dr. Panda is also from one of the university looking after technology transfer. So university is in the process of setting up in technology transfer office, and some of the university are doing great in that part, in collaborating, co-creating and celebrating. Third most important issue, you must understand the human capital at the service of technology transfer. What kind of human capital we are utilizing for technology transfer? That is most important, because if you can keep a people or official or the executive in your TTO, but who do not have some kind of specialization in mitigating the challenge, because we are not only dealing legal right as far as IPR is concerned, we are managing one asset, and that is an intangible asset. And process of taking technology left to the market, mind to the market, technology at bedside to the bedside, what are the learning mechanism, how to navigate to the market, that is most important. जो दिखता है वो बिकता है. But at the same time, we must to be vocal for local, because our MSME may not be the MSME of the other countries. Our MSME has own problem, own challenges, and also we have to mitigate accordingly at the local demand. And what are the agreement process we are doing, how we are managing, mitigating the technology licensing agreement as a professional in creating value and extracting value and also sharing the benefit. And last most important issue is, last two most important issue is the benefit sharing and also management of academic asset. This is, I am talking about a university perspective, since we have, I think, more than 900 university in the country, more than 11,000 engineering college. We have a hotel incubation center, technology business incubation center, I think we have created every institution you go today. We have a Atal ARIA ranking, Atal ranking for institutional innovation achievement, and many of the institutions are doing their best in creating IP. But how they are managing that IP, that is most important, and that is the biggest challenge, and that government of India has also understand. So national IPR policy came, and also the one of the biggest objective is IP commercialization. For that, WIPO has been playing an important role, and I myself look after one WIPO Technology Innovation Support Center. How we are channelizing Indian technology for global sustainability, that is most important. And for that, how we are managing it, scouting it, connecting it, and also documenting that technology for global sustainability, because we are part of the WIPO Green in facilitating Indian technology for global sustainability. And another point I wanted to apprise you all, as a technology transfer, national technology transfer organization, how we are taking Indian technology to the global world. And that I will give you one of the best case study. India, NRDC played a very important role in the past in taking Indian technology, agriculture technology in some of the country of Ghana and Mozambique and also Ivory Coast. We took the plant, we took Indian startup to showcase their product, and also we availed to this country people in adopting such technology, and today we became ornament in creating a opportunity of livelihood, because I'll give you one of the very interesting example of Ghana. Ghana import 90%, I mean Ghana was importing tomato from other country. But India helped in that growing of tomato varieties, Indian varieties of the tomato in Ghana. That NRDC played a very important role, taking Indian technology, Indian people, Indian manpower, and that handhold to the people of that region in demonstration, development, validation, handholding, and finally we have given the route and they are flying now. So that is the one of the opportunity India has been created in the global ecosystem of innovation. But certainly the issues of IP and technology transfer is nothing but the issues of managing Saraswati and Lakshmi. Although Dr. Panda touched upon mother and mother-in-law, but I will not talk on that point. But Saraswati and Lakshmi is most important. Idea is there. We have to leverage that idea. We have to validate that idea. We have to protect that idea. We have to transfer and monetize that idea in the both qualitative and quantitatively. That is the need of the hour in a ecosystem where we are part of it, to strengthen the regional innovation ecosystem and taking into a national innovation ecosystem, as well as taking that Indian innovation ecosystem to internationalizing innovation ecosystem for global sustainability. And these are some of my point, and that is need of the hour, and already we have put in place such kind of policy framework in the country. But it is the responsibility of respective university and institutional leadership how they are driving in connecting the dots. Thank you all. God bless you, Jai Hind.
So thank you, Dr. Bijay. And you mentioned a lot of words. So one thing you talked about WIPO Green, just for the knowledge of the audience. WIPO has started an initiative where they list down all the green technologies, whatever is available globally. So any company or any individual who has developed a technology which they feel that it's a green technology and going to work on sustainable, they can list on the WIPO website, and it's WIPO facilitate the collaboration with the potential licensor who could be. So that's the initiative of the WIPO Green. And you talked about, Dr. Bijay, about Saraswati and Lakshmi, so I'll talk about a little more on that, what you mean to say and that. So when we say IP, so it's a, IP means it's an invention. So in the corporate, so when you say that I have an invention, so and somebody says I have an innovation, and somebody else says technology. So all these three words have a different meaning for companies, because your IP protection gives IP gives a protection for invention. So when you say invention, so it could be a part of it could be a big invention, it could be part of a big, small part of the big invention. So that's what IP is all about. But when you say innovation, so companies look for innovation for a particular challenge. When they have something challenge, so they don't just say look for one invention, they try to find out somebody who provide a solution. So it could be, they look for innovation. So for them, innovation means something goes to the market, so gets used in the factory or in the process, or gets commercialized. So that's what general industries mean by the innovation. And when you say technology, so technology, I think from the corporate perspective, it becomes a little much broader than it's just invention and innovation. So it's like all the other component which is required to go to to set up the factory and go to the market. So essential component is what it's called about. It's called the technology. So a lot of time when academia and research institutes, they do their inventions or innovations, and they try to collaborate with the companies. The first thing comes the disclosure part, what they disclose, what they should disclose, what they shouldn't disclose. So a lot of time that challenge comes whether there should be some mechanism what they should disclose, what shouldn't be. So I'll start with Dr. Panda to share his thought, how do they go about it.
Yeah. As per the process of technology transfer, it has been started, information, your invention, you have to disclose to the buyer, okay? Because the disclosure part, if you have already a patent in process or you have a granted patent, it's situation based on that. If you have already granted patent, then the amount of know-how you are disclosing to the industry or to the buyer, the risk is little bit less. But if your IP application still in process of examination, and you are not damn sure that the chances of have a granting of that application is 100%, then you have to play a role. Yeah, your technology transfer office or your technology transfer professional has to play a major role that the know-how should be, because you have to furnish all the data after signing the NDA, because the NDA non-disclosure agreement also is a very important role play during a technology, licensing agreement signing. Before to this, you have a NDA with the, I can say the licensee. During that NDA, this is a legal document, you have to mention each of every point. In that part, there is a disclosure of information section is there. And what are the period of that information the licensee should keep in his ecosystem, and who are the person can reach to the information. So as per our standard of writing, that should be limited to their employee. It should not go outside any third party as per the NDA. This is first thing, because once the information is out of often from their ecosystem to other third party, let's say some legal entity or somebody else, so there is no surety that the data can also be reached to other party as well. And if there is a patent specification in the public forum, because you have to disclose everything in that patent, a person having ordinary skill in the art can produce the product or process into the lab by following the specification. And if all the know-how, all the details you have sharing to any person who is not coming under that CDA or NDA, that's very problematic to you. Basically in the context of India. As you know, it's very difficult to go to a court and prove a infringement lawsuit in India. It's very, very difficult. But in US, yes, you have an upper hand. If you have some good data in your hand, you can prove it. But in India, it's very, very difficult to take the damages from the, I can say from the infringer, okay? So we normally practice, make as stringent as much, don't transfer any material in initial stage. If you have something, I can say, let's say you have a product, though you have disclosing few parameters and all the parameters in the patent, still a person cannot reproduce the same product or process into their lab once going through the specification. There are so many. As I am from pharma background, I know mesalamine, metoprolol. You can read all the patent, you can get the know-how, still you are not reproducing the same product, same formulation. You can't do that. Pharma company, in the metoprolol, all the pharma company in India, they are investing huge revenue. There's a very good market, and getting the patent has been expired. still they are not reproducing the same formulation in that into their lab. So if you have that type of peculiarity of your product, you can disclose as much any data to the against party. But if you know your process is so simple, it can be easily reverse engineerable, and the product can get all the data by anybody, person having ordinary skill in that art. So be careful when you are drafting your NDA, what you are sharing to them. If you are transferring some material, so the MTA, material transfer agreement also, writing in that context, how to protect it. So each and every legal we cannot discuss here. So what are the limitation we are putting there, as I mentioned, to whom you are sharing, and who are the person can get access to that document what you are sharing to your future licensee. So these are the all aspect we have to take care of that during transferring of data or disclosing data to the against party.
Okay, so to adding to that, so in my experience, I have seen a lot of times, so during technology transfer and IP transfer, it's process little smooth in signing NDA, but a lot of time happens the companies or parties, they approach to a university or research center and they for their specific solutions, and they try to seek that if the other party can help them technically and provide the solution to it. And that time challenge comes that who is going to be the disclosure for this confidential information, whether the party who is disclosing it or the academic institute or the research institute who is going to provide a solution, they are going to disclose. So, and lot of time, both parties don't agree to it, and lot of it goes to lot of discussions, and it takes a lot of time. So I would request if Dr. Bijay Kumar have some experience on such challenges, and he can share.
Technology transfer is nothing but कभी ताली भी मिलेगा और कभी गाली भी मिलेगा. So when we are talking about transferring any university technology, and I will caution, sharing and caring is most important, and trust is most important. If there is a IP protection, we must have to share the information based on our collaboration, and in that collaboration part, we must look into the liability and redress. And in that liability and redress, we must have to create such kind of mechanism so that there should be a win-win situation. So technology, particularly university technology, yes, university has own challenge and own opportunity. And being an institution of academics, their technology may not be ready for commercialization. So what are the benefit of opportunity we are taking from industry in doing the technology validation? I'm giving one example of one of the institution where the industry help and handhold for validation of technology, because they had a industry academia collaboration for that purpose. So we have to identify the partner, and that partner is none other than the partner who is existed there. So they have a trust, they have a belief, they have a understanding, they knows very well about the technology because they are the creator. They are, mother of the technology. So because it is a collaborative technology. So, but in that part, the issues of intellectual property protection, many of the university do not have an awareness. Particularly is that every day years you have to pay annuity fees. Who will pay that annuity fees? Whether particularly many universities do not have such kind of funding for payment towards annuity of any patent. So one technology may have many patents. So who will be the responsibility, and how the intellectual property management cell is there or not to mitigate such challenge? So that is one of the challenge we do as a national organization. Not only to that, we also protect the IP. Not only patent, we look for copyright, design, and if it is a startup, we also handhold such kind of startup. We bear the cost for the same also. So that freedom to operate, we channelize, manage, and second is the technology validation and also certification. जो दिखता है वो बिकता है. So how you are certifying, because we are in a transparent ecosystem, we can't misguide or misinform to anyone in the knowledge economy, because this is a knowledge economy and it is knowledge intensive and knowledge must be acknowledged. So that is most important for an institution like us to safeguard the institution, individual, mitigating all form of challenge when we are licensing any technology. And most important, I must not forget, when we are transferring any technology from a public institution, we must look the objective, identification, as well as the term of licensing, because we are transferring from a public institution as far as the technology is concerned, that to a industry or startup or MSME, we have to mitigate the government policy so that it should not be a problem against the administrator of that university or institution or the inventor. And lastly, as per the IPR policy of, the policy that has been put in place as a reference copy in our government of India, the IPR policy framework we must adopt to create a benefit sharing, ownership, liability, and also transfer of right. That is most important, because we have a larger ecosystem of educational institution in the country. So invention, innovation, as Dr. Panda told, that university is giving many more technology in the recent times, and we have to look and create the opportunity for that in bridging the gap between academia and industry and technology transfer. And we must have to acknowledge it fast, because acknowledgement gives opportunity to a professor or researcher that he is or she is created of that invention, that will give the opportunity or supremacy in the field of invention, benefit sharing, recognition, rewards. In fact, NRDC was giving National Innovation Award, Budding Innovation Award from a university who creates such kind of IP and invention, taking into a next level. And that has been there, and that will create an opportunity for them to showcase in the global economy for more collaboration towards sponsored research, collaborating research, granting-led research, and also contract research, because contract research and these are not there in Indian university and looking for that institutional framework. Thank you for giving this opportunity. So anything else there, certainly I can do my best. Thank you.
So thank you, Dr. Bijay. So Dr. Panda, so I would like to ask a little more specific questions on the same topic. That do you have any standard licensing agreement, or you decide on case-to-case basis? And further to in that, if you can cover on that, how do you take care on the, suppose you have licensed a IP. So if there is improvement in that IP, who is going to own it? And if your license is, what type of license it's a, and is there a, like you say that whatever I am giving it, I am responsible. Tomorrow something goes wrong, somebody says that it's you are infringing somebody else's right. So who owns that, takes the liability part? And is there any other thing you consider that, because when some other party pays money, he wants value out of it. If he's paying 10 rupees, he will definitely, he is going to seek that his 10 rupees is going to recover in next 1 year or 2 years.
Yeah.
So how do you ensure that all the expectations of the other parties met?
Yeah, as per the licensing drafting or licensing agreement, it's not at all same. It's based on product to product. As per the classification of licensing agreement, we are targeting maybe exclusive licensing, non-exclusive licensing, or limited licensing. Okay, based on that division, exclusive licensing we will know there is only one licensee. For non-exclusive, there are many more licensee. Okay. And for limited licensing exclusive agreement, it based on jurisdiction based. Let's say you have a patent in India, or also you are protecting your invention in US, Europe, then you will choose a partner in India who can sell the product in India only, and that same company has not that much of strength or capturing in the US market, then you can also give that licensing, only limited jurisdiction licensing, to company A for India, and for company B, who have a better or deeper reach to the market, you can give the jurisdiction of the US to company B. So this is called restricted, and also it can be also used based. Let's say same product, let's say you have a microbiology based light, nowadays it's a green light called. You can use somebody, you can give the product for street light, somebody for household. It based on the use limited exclusivity. So based on the targeted customer, who is your customer, how much strength of that customer, let's say I am selling my technology to a bigger company like Tata company, then I should target for exclusive licensing. Let's say there is a company of mid scale, then it will be preferred to me to go for a non-exclusive licensing, not for a licensing, because the company cannot give me that much of upfront payment, or also I cannot get that much of revenue generation from royalties. That based on who is the buyer, about your technology, and about your IP protection. The second thing is that as per in which way, because we are all the time thinking about patent. But nowadays the trend has been changes. Let's say patent only give you 20 years of exclusive right, and out of this somebody can infringe. As I earlier mentioned, in India it's very, very difficult to catch the infringer. And also it's okay, you catch them first, then to prove it and to take the damages in the court of law in Indian jurisprudence is very, very difficult. Okay. So nowadays most of the company they are playing like as a trade secret. That's also a very great aspect. If you really think your product comes under trade, you can manage it under trade secret, then you should choose the IP of trade secret, not go to the patenting way. Because patenting means you are disclosing, you have lot more of challenges. And one more thing, as I hopefully most of the people know that, the most number of highest sue made against a person who has invented telephone, Graham Bell. 640, sue has been had filed against that guy in US court of law in total. Can you think? Because the invention is a huge, all the bigger company, when that guy tried to licensing the product to one company, the other company they try to, I can say it's an tactics of pressure. Okay, 640 litigation. But these are also one aspect to that is smaller company, MSME or any academia part of that. So as my experience, what I am sharing, it's product to product based. You have to evaluate diligently, okay, where your IP is. If in Indian context I am saying, little bit we are doing good in global context. Still, if you are checking, more than 80 to 90% Indian patent, they don't have any PCT, they don't go to any other country to protect their invention, because they are only targeting, yes, I have an Indian patent, that much okay for me, because they are not, because they don't know how to commerce. This is the role of IP, technology transfer. Because if a company, smaller company or MSc company or a academia, if they don't know how to generate revenue from their IP, so they are not interested to protect their patent in outside India like US, Europe, because getting patent is one thing. After that, you have to pay the maintenance fee till expiry of the patent. For that, you need revenue to pay the maintenance fee. Okay, so these are the aspects about that IP status, IP coverage, then type of product, and who is buying. Okay, who is buying your product? So, and also what is your patent life? If there is a patent life of 4 or 6 years, so then you should choose for a non-exclusive pathway, because nobody is interested to take the exclusive pathways. So these are the factors normally we do consider when you're going for the signing a license agreement during our normal, normal pathways of course of action.
So thank you, Dr. Panda. So just to add my experience in that, so most of the time what happens, people try to license their IP and technology, and if you see the success rate, that's not so great in India. But one thing I have experienced in the corporate, that what works well is instead of licensing, go in a collaboration mode. So like initially I said, na, एक अकेला थक जाएगा, मिलकर हाथ बढ़ाना. So what companies prefer to do that from the initial stage, they try to identify who could be their potential customers from that company perspective. And instead of developing a product and technology and later on offering them as that this is what you buy it, they collaborate initially that, okay, let's do it together. you develop your market, I'll develop my technology, my product. So they build a consensus as that what is the transaction is going to look like where both parties are win-win. So what other partners get, they get a first access to the new technology, new product, which is not available in the market, and the developer or the other developer gets the customer ready customer that if his product is successful or technology is successful, he has a ready customer. So that model I have seen in the corporate, it works well, very well. So that's one thing I think can be adopted for other academia and research institute as well. So, and that's I think good model. And the risk of IP is less minimum there because parties are clear there that what they are expecting from out of this collaboration. So it's not about a license, state license, it's a collaboration, both part, it's a collaboration thing. So, and Dr. Bijay has been saying about benefit sharing. So benefit sharing, there are two concepts. One is when academia, university or a research institute, they license their technology, some of the amount goes to the professor or scientist. So, but in corporate, I think that's not a mandate in India, but in Germany and some other countries, there is a law that inventors should get paid if their technology gets licensed or commercialized. And another concept of the benefit sharing, which is very legal in India, it's called Biological Diversity Act. So if you are taking a license or collaborating on a technology from an academic or research institute, and tomorrow you are going to commercialize it, and it includes some biological resources, you need to see that if that particular technology requires a benefit sharing payment to the as per Biological Diversity Act. So I think now I'll open the floor for questions. So if anyone has any questions, please, you can ask. Please introduce yourself, then you can ask your question.
Sure. Good afternoon. My name is Renuka. I work at a law firm, Lal and Sethi. It's an IP boutique firm based in Delhi. This is a very interesting discussion. You talked about how in some situations licensing does not work, and in that case collaboration is probably the way to go. But does that not lead to questions of who will then own the IP that is being created if you are collaborating between two parties?
In collaboration, that's the interesting part. I have seen that parties collaborate with their potential customer mostly. So they know that this is my domain, this is my boundary, and this is what the other party's boundary. And that time they decide that, okay, let's own the IP. In my boundary, I am going to own my IP, and beyond that, you are going to own anything jointly. They prefer not to go jointly. If there's a joint, that time they figure it out, because joint thing sometimes sounds very good that I have a joint IP, but for a company like us, joint IP does not always help us. So that's why in the initial phase itself, they decide that what they are going to own, what if you want to own, you own it, but what I am going to develop for that, I'll keep it public.
Yeah, for that, there is a term sponsor research agreement, okay? If you have developed invention from academia or startup or MSME, then you reach to a bigger company. If they have evaluated and they are not that much of damn sure, okay, they should buy the technology from your ecosystem to their site. So they are agreeing for sponsor research agreement. They are putting some money to that do some much, generate some few more data for that, I can say for pivotal batches. So in that way of line, already you have generated IP. They are putting the fund for that. On that basis, they have a agreement earlier. Okay, once there is promising data generated out of this further research, they will hire your technology. As per the licensing agreement. Second part is that your collaborative your questions. Let initial stage, If they think your university, let's say Massachusetts Institute of Technology, then Cornell University, they are normally called as a platform technology based university. The university, the industry ecosystem knows that they have very good talent pool, and initially we should collaborate with them. You know, nowadays in Chennai IITs, most of the industry also, they are doing such type of collaborative research. And in that part, as he rightly mentioned, because if the party is IIT Chennai and one party is, let's say, a bigger MNCs, okay, some institutions, they are normally thinking, of course, yes, they are looking for the generating of revenue. Still, they have little bit soft corner to the socio-economical impact. But as a MNC, you know, they are pure business guy, you know, they are thinking for revenue. In that way, the conflict is coming, okay. So normally what happened that time, mostly the bigger company, they told we are paying you. Normally in US they are playing in that way, you know. I can say it's a assignee transfer. If I can check in US, the assigned transfer is very common, but not in India. In India, if you are coming to a university and yeah, you know, to a professor, if the professor is an applicant of that Indian patent application, the company is wishing to take the assignee. The innovator, you can't change the innovator as per the law, patent law. Innovator will be same throughout the life of that patent. There, you know, they thought कि नहीं मेरा सब कुछ चला जाएगा भाई, you know, I have lost everything. But it's a very common practice in US. If you are following that pathways, you know, because assignment is the major role. Who is going to sell the technology, and as per their signing agreement, the percentage of revenue come to the innovator. If that will be the pathways between the collaboration, let's say the MNC will take the assignment part, and in initial stage they have a license agreement. They have an agreement between them. Out of the revenue generation, I will pay 30%. You have 35% or 40% to the innovator. And nowadays in abroad, if you go there, so they have a pattern like that. If you are generating this milestone payment, this is called. If we have generating this much of $1 million, then the percentage is 30% to the innovator. The company will take rest the same. If it is cross, you know, 5 million, then the percentage will be higher little bit, lower little bit. So that will be the right way. But putting assignee to organization, it's very difficult. So you have to, as a company, you have to give that much of lucrative amount of, you know, percentage to the innovator. But then hopefully you have a better chances there.
Thank you. I'm Advocate Sanjay Chowre. I have a curiosity about liability in technology transfer of various stakeholders. Could you throw some lights on that, please?
So, liability is one of the, mainly in technology transfer, there are two kind of liabilities generally arises. One thing is the performance of the technology, and the other is the third party IP. So mostly companies go for FTO kind of study. So FTO called is freedom to operate. It's a due diligence study which gives you that whether you are going to infringe somebody's patent or not. And that based on that, parties decide that who is, because if it is a academia or research institute, generally they don't take any liability beyond what you are paying them. So because they say we cannot pay you more than what you have paid to us. That's the maximum they can give you. And on performance side, so as a corporate, we generally prefer instead of going directly. So any the practical aspect, we prefer to go on milestone base. So instead of going directly and take a license directly, first you let them like Dr. Sahu mentioned about technology readiness level. So check that their technology readiness level, put the milestones that you ensure that your payment is linked to the milestones. Once they complete the milestone, then you make the payment and give your royalty and whatever based on that milestone. So that's how they try to minimize it. So there's no standard answer to it. So it's based on the mutual.
I add to that, you know, as you rightly mentioned, FTO clearance, freedom to operate, you know, this is the backbone of any licensing agreement. Second, the IP valuation, you know, that's also very important because though you have a granted patent, it doesn't mean nobody can invalidate your patent. It's a normal practice in US. For all the generic company, they are normally try to invalidate the granted patent, okay, to have a settlement with the plaintiff. The third part is the milestone payment, as you mentioned, okay, because never ever you draft a license agreement like that's one-time payment. No. During license agreement, let's say the upfront payment and royalty, there are two type of payment, okay. As per our technology transfer ecosystem, let's say the valuation is X amount. Out of the X amount, 20 to 30% should be covered during the upfront payment. And rest 70 to 80% you should put in the royalty base. Because royalty, once the product is in the market, then there will be no loss to the company, also no loss to the innovator. During also that 20 to 30% of the upfront payment, you should go for the milestone payment. During signing 10 to 20% or something like that, okay. After that, because the transfer of technology from the site of innovator to the site of your company, it's a huge. In pharma, I know if you have a product past the pilot scale study, there are 50% failure in pivotal state studies. Its variability is there. You are preparing 100 product, you can pass the test. Once you go for a larger manufacturing 1 lakh product, there is much more variation is there. So you should, based on the milestone payment, in 3 or 4 milestone payment within 1 or 2 years. Okay, and the milestone payment also like a upward hills, not downward. The initial payment will be little bit lower, 10 to 20% is increasing. But this is the way you can, because you cannot put any liability use to the innovator. If you are putting the liability clause completely on the innovator, if that is a startup company or a professor, then I can say it's against the natural justice. Because they can't bear. They are inventing something, they have given their report, you as a MNC, you have that much of strength, manpower. You can go for the freedom to operate searches, you can go for the, ask for the milestone payment, you can know the market, market forecasting, everything you know. And you have a talent pool, who can evaluate the technology aspect as well. So this is the normally, we are playing in that way. So because as a technology transfer professional, normally we do play we have to protect the interest for both the parties. And because in other words, most of the bigger company, they are taking the technology. After that, they are not caring the innovator. Because they know they are not, because you all are lawyers, an innovator can't pay you that much. The professor can't pay you that much to fight a case in the court of law. But the company has a, man of 20 or 30 big lawyers. They will bully the innovator, in the court of law. But this is also a risk to the innovator side. So we as a mediator, I can say, facilitator of transfer the technology from that ecosystem to the bigger ecosystem, we have to take care of both the parties' interest, Yeah.
Hello, I am Ananya Agarwal from Ace Legal. Sir, you mentioned that the trend nowadays is to go more towards trade secrets than patents. What I wanted to know is what are some considerations as, say, an inventor or owner of such technology to go towards the route of trade secret and not actually go for filing of the patent?
Yeah, it's a very interesting question. In US, the trade secret law is so strong, but not in India. For the trade secret, let's say you are a MSME or you are a startup company, you have some employees are there, they have to, often to their, your know-how. So during giving your employment, you have to mention such type of stringent section in your employment letter, appointment letter. Okay, they should not disclose anything to any party, or if they are joining to next company, the same person should not be party of that such type of invention. That will be comes under conflict of interest. Okay, you have to putting such type of clause during giving the appointment letter first of all. Second, you have to choose. Should I go in patent pathways? As I mentioned, your know-how, how complex is it? It depends. If it is a very simple process, you should not go for the trade secret. If one day you are launch your product to the market, some same player who are playing in your same code, they will take your product, reverse engineering your product, they can get the know-how. So your technical acumen should like that. Is it a simple or is it complex? If it is a complex, then go and choose the trade secret. Though your employee not disclosing the same to the market, but somebody, other party, they can generate the knowledge, okay, from the product. Third party is that if your product is a combination of A, B, and C, okay, let's say you have a component A producing by X employee, then B, and you should not have a contact between A and B. You can also place that such type of equation as well. I can say it's contributory innovation, okay. So you can strategize accordingly. You know, it's not like everything I should copy. Trade secret is the best way. You have nothing to, invest money, nothing to pay any IP lawyer, nothing to pay a maintenance fee, but the risk is higher. So this is a balancing between what's your technology, or the way, in what way you should move ahead. That's why I'm giving you an example of bacteria, As for the section, you can have a patent on microorganism. Let's say your invention is based on that consortium of bacteria, okay. Then, as per the law, you have deposited all the things to the NBA, National Biodiversity Authority. As per the Patent Act, never ever you can get each and every detail of the bacteria in the patent specification. You can have putting the code, which is given by the NBA. So in that case, you should go for trade secret. But nobody can get each and every information about that bacteria, how to prepare, what are the all details of that bacteria from patent. The only code will be mentioned in that, and all the information will be with NBA, which is highly confidential. In that case, with a blind eye, you should go for the trade secret. So these are the in which field your product is actually. Okay? Yeah. Sorry, the person is waiting for that actually. Yeah.
Well, my name is Ahmed. I'm practicing law in Egypt and Saudi and Emirates and Jordan. I'm currently leading the legal team of one of the health tech companies in the Middle East. So I have a couple of questions. I wanted to follow up on a couple of discussions here. So regarding the protection of patent and trade secrets, I believe the patent is more weighted than the trade secrets, because even if you mention something in the employment agreement regarding the trade secrets, practically you won't be able to protect your rights. I've seen like tens or hundreds of cases where employees jump from a company to another and use the X company's data, even to establish a new company competing with the X employer. In Egypt, for example, I've been working on a case. A company that was actually developing a software for booking doctors. So they had a platform or a list of doctors with this list of specialties and addresses and the fees paid. And one of the employees that we used to work for this company started his own business and took the list of doctors, and it's a pure competing business, and the ex-employer sued him, and his defense was that this list or the development the company has done to the list of doctors, you can find it on Google with the name of the doctor, the address, and so on. And although the Egyptian intellectual property law says that any sorting or grouping or listing of specific data shall be deemed as a patent. But on ground, as I said, on ground, the burden of proof is impossible. Responding to your question even regarding the NDAs or anything related to this, it's very hard to prove that this employee stole this specific thing from a place to another place. So I believe keeping it as a patent is way better than dealing with it as a trade secret.
As I mentioned, okay, as per the NBA, what I given the example right now, this is related to microimage invention, okay? You can go for the trade secret. Nobody can say, get the data. Not at all. Because this is coming under your NBA. So I am not telling you are not using a patent. No. If your product is so complex, as I mentioned in the last part, the mesalamine and metoprolol, this is a drug, you have patent. You cannot generate any, same product in your lab. So you have to check what's your product, in which field it is, and it's simple or complex or not. Because in patent, as Coca-Cola, any company can till yet produce no reverse engineering of Coca-Cola product. Am I right? So how it's protected right now? And also, it depends on the jurisdiction. As I mentioned, in India, there is no stringent, hopefully in developed and least developed country as well. But US, they have a very stringent law in trade secret. Because you have to prove in court of law, if there is any infringement of your trade secret. So that depends on the legal jurisprudence of that jurisdiction.
Okay, and about India, for example, the UAE published a new law a couple of weeks ago that if an employee breaches the NDA, a fine may reach like 500,000. Yeah.
I'll just add in what he said. So one strategy doesn't work. So it's like you have a patent and some information you can keep it as a know-how, because which you need to decide on case-to-case basis. There's no standard. And as such, trade secret is not a formal protection. It's you need to keep it secret. So you need to take a measure in all those things. And other people are free to do the same thing, create, reverse engineer it and everything other than your employees. So only you can bound by your NDA and contract to your employees or somebody or partners to whom you are disclosing. Rest of the world is free to create and develop it same thing. Like in microbes, he said that's opportunity, but other person can isolate a better bacteria, so that's microbe. So that opportunity is there, like you said. So yeah, it's not. And in India, so for employees, there is a contract act. In contract act, there's I think section 27, which says that you cannot have a restricted employee. You cannot restrict an employee working in the same area. So you cannot formally say that unless you prove it that he has taken data directly from your company and misused it.
I'm Professor Aparna Raman. I am a faculty at my university's National University of Singapore and at IISc. So we have a lot of research centers. My concern, because the universities, the research centers are also basic and applied research. There is a distinction, number one. Only when it's applied in a commercial aspect, but there's a lot of basic prior research to that. My concern is a lot of issues that we've seen is regarding the funding. Not just attribution, but also allocation. The percentage, the proportional allocations. Attribution is one thing, but allocation and association is another, because anything the wheel is never going to be reinvented. What we are going to do is derived and based on certain, for example, AI. A lot of our work uses AI and these emerging technologies where there's a component of AI-led and there's a component of human-led. So how would you attribute, how do you segregate, how do you allocate this? And the point is that these researchers are being increasingly collaborative in nature. There's no person who's going to do it singly. It is always in a group, a team, in an MOU between institutions, and mostly it comes out of institutes and then the industry. There's a lot of linkages between industry and institute. So how do we, is there any policy effort at all in this country, which I don't see at all, because there's a gap so much, because outside we have a treaty level, we have the international law level, they're harmonized, but here there's absolutely no policy when it comes to R&D, allocation and attribution, especially when it comes to funding. So who is it anyway, and how do you take a long-term view of it, because these are long-haul projects, they are not a day-to-day, you take a 5-year, 10-year gestation, you take the generational view of institutionalizing it. Thank you.
Thank you. I think what you said, it's a gap, so it's a challenge, and currently there's no solution to it. So let's hope that people like you come in such forums and raise these things, and someone comes with the solution to it. That's what only I can hope. So the last person who is the...
Yeah, actually, you rightly mentioned, because you can see from our Indian aspect, the fund we have allocated from our general budget, it's very less. As per your fund allocation matter, what I can say as of now, let's say you are a researcher, you are from academia. Initially, I hope you have an idea, there are so many funds you can get it from government. initial stage to reach the technology readiness level 3, proof of concept in your lab you can develop. After that, there is a second lineup, okay, where you can transfer your technology from readiness level 3 to 6. But it's a highly competitiveness. So let's say recently NRDC given like 1 crore to 2 crores. There are MIT is there. Yeah, you have to target that as well. There are, I can say, near about 10, funding type of, I can say, agencies in Government of India. You have to apply for that. And thirdly, venture capitals. Okay. As per the research, if I am putting that, earlier there is an investment of huge in startup company in India, near about 22 million. Right now it's decreased to the 7.5 million in 2023. There is a decreasing. But the funding to AI, clouding system and space research done by some startup or faculties, this is good. But other than to this is very challenging. So for getting money from AI or VC. That's the role played by technology transfer activities.
The other challenge is what is AI based and what is human based.
Okay. About that, you can contributing that machine invention. It's a topic right now throughout the world. The machine can be an inventor or not. So we can discuss out of that. Yeah.
I think let's take the last question and then close the session, and because we are
limited of time. Yeah.
Your lunch and you.
Hi, greetings of the day. Tanishka this side. I'm working as a legal counsel in NGO by the name of Save the Children India. So, working as a legal counsel, there have been n number of agreements that we encounter. So when I talk about branding, collaboration, white labeling, and different donation agreements, being an innovator or being owner of the IPs, till what extent should we give the usage consent of the IPs to other party in the agreements?
I think there's no standard answer to it. You need to decide that what is your plan for that. So if suppose you have a technology and you have an innovation on that, what you want to do with that? Whether you want to commercialize to this party only or you want to give it to somebody else. If you have a future plans, then you can restrict it to the party. If not, try to get the maximum value what you can get from the party you have who is ready to take it to the market. That's my suggestion.
Yeah, for that, as I know that a child continuity to IP. IP means patent if there is a patent, parent patent. And as per the licensing agreement, you have to put the patent number there. What you are covering, in US context, this is called child continuity, okay, patent greening. In Indian patent addition or divisional patent. All the time should try, no divisional patent should come under the license agreement. Because your divisional patent will be a little bit different, invention. It's not coming under unity of invention, okay. Child continuity you have to put. Because without parent, there is no standard loci of a child continuity, patent in addition. So as per that, we as a techno transfer professional or IP professional, we are taking care of that license agreement should only capture that family, not taking anything beyond to that. If I am doing some derivative research, so that license agreement should not controlling over that. So during drafting, you have to categorically mention what you are covering. If you are not upon that space, then that licensor will going to lose a huge in future. So licensee all the time try to open that pathways. But we as a licensor, we should all the time try to shut down it, not to open up, it should be shut. Because only we can give the child continuity because you have to give that, not beyond to that.
So with this, I close this session. So thank you audience and thank you LexTalk and thank you panelists. So Dr. Bijay.